Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Public Procurement Bill 2012, which is the first of its kind bill which attempts to provide an umbrella framework for all procurements of the government. It seeks to induce transparency and accountability into the procurement process. To discuss the issue, I have with me Mr. Keshav Prasad Verma, former member Railway Board, and Mr. P.S. Bami, former Chairman cum Managing Director, NTPC Limited. Now for the headlines. The bill tries to deter cartelization and rigging of government procurements. The bill tries to ensure transparency and accountability on all deals above 50 lakh rupees. And it provides 5-year imprisonment and fine for lobbying. The Public Procurement Bill 2012 seeks to deter cartelization, rigging and collusion in bidding process of government procurements. The bill seeks to bring in transparency and accountability in all high-valued government purchases of over 50 lakh rupees. There is no existing law governing public procurement except the General Financial Rules of 2005.
There have been instances where the private sector has colluded to corner huge government contracts, resulting in rigging of the bids. Besides financial rules, there is no legal framework to contain activities like rigging. Now the government proposes the Public Procurement Bill. According to the bill, every purchase made by government department from a private sector will be subjected to public scrutiny.
It was one of the great concerns that there was sort of anarchy. A little while ago, you asked me a question whether the scams which took place in Commonwealth and others, they would have taken place. Well, if this bill were there, not, because all the public sector undertakings were permitted to frame their own rules, whereas this act says that all the procurements now will be governed by these. So that was a time when there was a lot of anarchy.
The bill empowers all government departments to act as procuring entities. Any company in which the government holds more than 50% paid-up share capital can also act as a procuring entity. The bill makes procuring entity responsible to ensure efficiency, economy and transparency in procurement process. The procuring entity must provide a level playing field to bidders to promote competition and ensure a reasonable bid price for the product. It also tries to prevent corrupt practices in bidding processes by inserting an integrity clause. The bill enables exclusion of any person from the process if he is found indulging in unfair activities to influence the bidding process by bringing bid rigging and improper use of information provided by the procuring entity. The bill enables cancellation of contract and debarring person if they are found in a serious offence involving huge money. The bill also allows recovery of payments made by the procuring entity along with interest.
Seen there are a lot of escape clauses. One is what is security, strategic interest. Then there is our provisions for making exceptions in certain circumstances. Then also restricting, you see, because after all, the main procurement is the open competitive bidding.
The procuring entities will also need to maintain documents to explain the need for the bidding process and a catalogue of bidding products with the quality and quantity. The government may divide the procuring product into packages in order to ensure efficiency, economy and timely completion of bidding process. Major Indian government departments like Ministry of Defence, Indian Railways and Telecommunications spend 50% of their annual budget only on the procurement process. If you recollect the Commonwealth Games and the 2G spectrum scam, we can imagine the amount of corruption involved in that particular scams. If we had a legislation like this public procurement procedure, the situation would have been completely different. Rajkamal Rao, Rajya Sabha TV.
As per the bill, procuring entities must opt for open competitive bidding as a method of procurement. How important is the L1 factor and how is it impacting the procurement? Mr. Keshav Prasad Verma ji, sir, how do you think is the L1 category going to impact in the overall umbrella framework that we have? The lowest one.
Yes, yes. The The very basis of public procurement is open competitive bidding. When one tries to find out what is the market, and when we find out the lowest price, then that ought to be procured. So this is one of the most important provisions of public procurement, that buy from the lowest.
And buying from the lowest essentially means without any prescriptions of the quality.
I am sorry, you said
Without any prescription as to the quality of product or your actual requirement.
No, it doesn't mean that. I think you are going deeper into it.
Yes.
When we say the lowest, we mean what is most suitable. We call it technically responsive bid. It must be with all the technical qualifications, should be able to do what we want to do, and then it should be the lowest. So in a process, if we get say 10 offers and the first, second, third, they are not suitable, they do not meet the criteria, then they will not be taken into account.
Do you think the lowest one is somewhere creating a problem as far as procurement is concerned? And does this bill addresses that? The issues of quality, the issues of specialized requirement, the issues, because if you create a parameter of L1.
As I explained to you, when we say L1, we do not mean the lowest price that we have received. We mean what is the lowest among the technically suitable bids. Well, the word technical itself is very wide. I am including here the technical capability of the firm, the financial capability of the firm, the experience. These are all the criteria which we lay down in the bidding document, that a bidder ought to fulfill all these criteria. If he does not fulfill these criteria, then he is not eligible.
Okay.
So when we talk of L1, we are talking L1 amongst the eligible bidders only.
Does it bring in the most required accountability and transparency?
First, let me add.
Yes,
to one
yes, you must,
sentence.
you must.
See, in the World Bank procedures, because they are the, very widely accepted in the across
Procurement.
the globe. They say that the most responsive, technically and commercially most responsive evaluated bid. The three words.
Yes.
Responsive, responsible to the technical specification, then commercially responsive. Your condition, somebody says, give me 50 lakhs or, it is lowest, but he says, give me advance of 50 lakhs. Now you have to evaluate what is the, what is the interest implication of 50 lakhs of rupees. So it is not commercially acceptable unless you evaluate it. So one is technically, commercially, and lowest evaluated bid. So that is the word which I think should be evaluate. I mean,
Does
when
the
you say
bill
lowest,
address that? Does the bill address
well,
that?
it does say that, you have to lay down the specifications very clearly. It lays down that.
The
law says that. I mean, the law says that.
Yes, that you have the choice and the right to.
The procurer has to lay down specifications very clearly. And then you have to evaluate with reference to that. You can't say that this is a better one.
So you are empowered to do it.
You are empowered to do it.
On the transparency and accountability bit.
Well, I think it's very clear. They say that you have no choice after that once you have evaluated it. You can't say that I like this bidder because he has been supplying to me earlier. There's no such thing. The question is that once you have made an open bid, then you have to evaluate. There's no question of somebody having more experience, somebody having supplied you earlier. So the law today is very clear, and this is something which is very important today. No ad hocism, no, something which are preferences. Transparency, then you can say economy, then you say non-discrimination. So these are the fundamentals, of procurement.
Do you think there should be a different parameter for specialized companies which have, or PSUs, and it should not be the same as that in the government? Should there be a distinction, or should all be brought into the same format of procurement?
I don't think there's any difference except that you say it's a defense, a strategic industry, or also there's a provision in which you say you want to protect some domestic industry. Then you evaluate, then you only limit yourself to such people. But otherwise, generally the law does not make any difference. But it does make provision. When there are specialized procurements involved, then you can limit yourself, under that provision. You have to decide that when the procuring agency has to declare it, that he brings it under that class. There is a class, which does give you the authority to do this kind of thing, if it is possible to, you want to determine that it is required.
It's time for us to head into a break. When we come back, we will talk about the penal provisions in the bill. Welcome back. The bill provides for 5-year jail term and fine of up to 10% of the total contract if one is caught lobbying. The bill seeks to exclude emergency procurements for disaster management and national security procurements.
All procuring entities will be allowed to frame their own categories for the bidding processes under the proposed legal framework. All the bidding activities will have to be listed on the public procurement portal and bidders will be expected to register. Only after they have registered will they be allowed to participate in any bidding process.
You see, the whole thing is that has to be one central agency which should be overseeing the implementation of this act. Personally, I feel, in the finance ministry, they have got to have professionals,
The Central Public Procurement Portal will provide access to pre-qualification document, bidder registration document and bidding documents. It will include names and particulars of bidders who have been debarred by the central government or a procuring entity. The central government will constitute independent procurement redressal committees. The committee will be headed by a chairperson who has proven integrity and experience in public procurement. The central government may prescribe professional standards to officials dealing with the procurement matters and provide suitable training and certification. The proposed bill allows classification of bids into categories like open competitive bidding, limited competitive bidding, or two-stage bidding and single source procurement. Any person found lobbying or influencing procuring entity will be punishable with imprisonment for a term of up to 5 years and fine up to 10% of the value of the procurement.
The question is that should we succumb to international treaties that we have signed to get into a procurement policy that would become unviable, that would benefit only people outside this country to source goods for India? And third, how do we protect domestic industry from these pressures?
The bill is based on the recommendations of the Committee on Public Procurement headed by a former IAS officer, Vinod Dhal. The recommendations were accepted by the Group of Ministers to Tackle Corruption headed by Finance Minister Pranab Mukherjee. As per the Public Procurement Organization's records, Indian government spends 15% of its budget needs on the procurement process. We have only Central Vigilance Commission to audit these kind of activities. The proposed legislation will bring in other agencies to bring in transparency in the financial audit of these kind of activities. Rajkamal Rao, Rajya Sabha TV.
The procurement entity will not limit participation of bidders except for the protection of public order and morality, animal or plant life, intellectual and national security. Well, that's a very obvious line. But my question to you, Mr. Kishore Prasad Verma, is what is the existing system and why is it because of the varying parameters of the procuring entity that we require this bill, or is the existing system serving its purpose?
Well, this is a very good question. In fact, this question could have been asked earlier. It is not that we have been working on the public procurement without any guidelines. We did have well-laid guidelines on procurement and it has worked. I am referring to General and Financial Rules, which was last revised in 2005. The concept of open tendering, the concept of buying from the lowest, the concept of accountability, transparency have already been there. It is not that they did not exist. As I pointed out a little while earlier, that the General and Financial Rules had covered only the departments of the ministries. It did not cover the public sector undertakings. Now, a study which we have made in 2000-2003, the total volume of procurement made by the central government ministries is much lower as compared to the public sector undertakings. In fact, public sector undertakings buy about 3 times what the central government buys.
Nice.
I am not including the defense procurements. I am only including the civil requirements.
Yeah.
So, we did have these rules. What the new bill does is, it extends the scope. Now,
To
all the public
PSUs.
sector undertakings and other entities also which receive money from the government, be it a society or be it in some other form, they all come under the purview of this bill. And this has been a very great step forward.
Right. I'll bring in Mr. You made a point, a very typical PSU point, that there should be professionals in the finance ministry. Do you mean that the bureaucrats handling this whole activity is not really up to the mark or not equipped specifically to cater to the procurement requirements of the PSU or the government?
No, but even the law itself says, you need specialists, procurement specialists, training, and then the certification. The word used is certification. That means the people who are going to handle this kind of job, not only in the procuring agency, but people who sit on on them, in the sense they lay down the system, they review the system, they get the feedback, and they make changes if required. The question is, are they qualified in the sense by experience? Are they qualified by certification? And even by, I would say that by their knowledge of the subject, that they can make necessary amendments which are required by a practitioner. The question is, it's not a Ministry of Law laying down. You see something being executed day and night. People who have got experience, what comes in the field. So I think personally, this my view is that you need professionalism in this area, and then there is a certain amount of experience and training required. So people who who want to oversee this whole thing, they have to be professionals, to my mind.
On the various kind of contracts that have been explained, that any of the models could be acquired depending on the choice or description that the procuring entity gives. But does it ensure enough penal provisions to take action if it is not followed, if any of it? Is the penal provision sufficient as a deterrent?
It is, I would rather say that it is not sufficient, it is much more. The penal provisions which have been put in the bill, to my mind, they are going to instill fear in the minds of the procurement officials. I am surprised that why all these penal provisions have to put into the bill. If you read the bill, right in the very beginning, there is a code of integrity, which also lays down certain penalties, and which can be imposed if the code is not followed. Why that is not enough? We are giving penal provision that for lobbying there would be a imprisonment for so much and so much fine. You might recall in late 80s, there was a directive given by the government that no agent, foreign agent would be employed when government buys any imported material. Did it succeed? Immediately after that, we had that famous case, which we all know. I am talking about the defense procurement, Bofor's case, to be precise. So, lobbying, can we stop lobbying? By lobbying, I don't mean that somebody tries and come to influence the procurement officer. I am talking about all the development,
external lobbyists,
all the development which are taking place in the world. We want to take the latest technology. How do we come across that? We do need these people. They ought to come and explain to us. We do need to know what is the latest technology. We do need to ask them, interact with them. It does not essentially mean that it is non-professional.
But misuse of any information or granted by the procuring entity to the person, that also will debar the person from. Do you think that's too harsh?
No, that I would not say too harsh. In fact, there is a clause on confidentiality in this bill.
Yes.
That is a very appropriate clause. So I am not commenting upon the confidentiality or integrity. I am talking about these measures on the penalties, offences and penalties. They are too severe. They might serve as a deterrent.
Should be moderated a bit.
My view is that it needs to be very, very much moderated. In fact, there should be a relook. Why can't the existing laws, like the Indian Penal Code,
automatically,
or Prevention of Corruption Act, not take that into account?
On that note, it's time for us to head into a break. When we come back, we will show you an interview with Mr. Vinod Dhal, former Chairman, Competition Commission of India. Welcome back. My colleague Rajkamal Rao spoke to former Chairman, Competition Commission of India, Mr. Vinod Dhal, and tried to get his perspective on the issue.
Vinod sir, please explain why we need a separate legislation for the public procurement process.
There is no single legislation which covers this vast activity. And if you look at procurement, it is in many ways the public face of government. In the public perception, it is also the soft underbelly of the governance structure, where a lot of activity, undesirable kind of activity or corruption.
For the checking, auditing and inspecting purposes, we need a lot of human resource to implement the government's concerns. Do you think government is going to create any particular department for these kind of activities, sir?
Yeah, as I said, we recommended that there should be a separate department of procurement. In the United States, for example, you have the Office of Public Procurement. And that is given statutory powers. That office has... So, government has decided to set up a division within the Department of Expenditure. And I would say it's okay to start with at least a dedicated little organization has been set up in the Department of Expenditure, and that will do the work which we recommended for the department.
So, central government spends 15% of its annual budget on the procurement process. What about the significant checks and auditing in this case? Is CVC the only responsible thing in this, or do we have any other operators who are doing this?
But generally, we've observed that the whole process is a little bit unprofessional. And secondly, there is no real-time leadership. The Ministry of Finance is the obvious and the right place where procurement is dealt with, but they are busy with so many other things. So in procurement itself, if any clarification is required, any guidance is required, there is a certain vacuum. As I said, when I was doing the MCA 21, I did not know whom to go to and get some guidance. So by default, the CVC, who is supposed to be the watchdog, has also become the nodal point for seeking clarifications. And the CVC himself has said that, look, this is not my role. Government should provide for somebody to exercise this leadership role, professional, somebody who can provide real-time guidance, professionalize the whole process, undertake training, etc., lay down the rules, lay down the regulations, standardize the documents, run the portal, and the rest of it.
The central government may make procurement mandatory from certain bidders only on the grounds of promotion of domestic industry, socio-economic policy, or other considerations in public interest. My question to you, sir, Mr. Bami, is that review and redressal before the contract and after the contract, both the points, does this bill address that aspect?
I think this is the very fundamental feature, which is something very welcome has come, because you see that the aggrieved party earlier had no escape except to call for arbitration or go to the courts. Now at least, they can claim, they review, because if they feel really justified in their claim that justice has not been done to them, then I think they can put forward the review. And the review that the system provides for very expeditious clearance of the review petition. So within about 30 days, it has to be disposed of.
Redressed, yes.
And if they are still not, because this is again a departmental thing, but if they feel the department has not done again justice to them, then there is a redressal committee presided over by a judge of the High Court. And they are all professionals attached with him. So I think this is a very, very welcome thing in which, the man will feel that things, at least whatever he has got to say, it has been listened to and some addressal has been done. But at the same time, it cannot be frivolous. Not anybody can make a, all sorts of
So there is no deterrent for frivolous complaint.
There is
a deterrent also.
So then both the things are important, which have been included in this bill. I think it's a very welcome feature.
Mr. Verma, the dispute redressal after awarding of contract, one, and also on the professionalism not being encouraged. Does the bill address these 2 points?
Unfortunately not. The bill which has been drafted, a very well drafted bill, only takes into account the checks and balances. Not that the government did not have checks and balances earlier also. It introduces into a much larger measure. But The bill has done nothing to give a guidance to the professionalism. What are the problems which are facing public procurement in the country today? It does not address them. Take for example the construction of your national highways. Why it is held up? It is held up only on account of defects in contracting.
Yeah.
The contracts are not placed as they ought to be, and the moment they are placed, they get into dispute.
Right.
Therefore, a bill ought to address the disputes in the contracts also.
Yes.
I am aware that this bill, a scope of this bill is up to placing the contract only, and my regret is that it should have extended and included this important aspect also, which will give a great fillip to public procurement in this country.
Right. On that, thank you very much, sir, for joining us on this discussion and show. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.